admit all then.
It now says we are live streaming, so you should be clear to admit everybody, especially.
Okay, I'm going to go ahead and do that then.
Okay.
Let's go ahead and go. And you're recording too. Start the recording, please.
It now says we are live streaming, so you should be clear to admit. Sorry. It gives a little echo.
Yep, we have
Okay,
it.
so good morning, everyone. Just bear with us for just a moment while everyone gets online. And we're going to start the recording.
Hello, can you hear me?
Yes, we hear you, Mr. Simoni. Just a minute. I just am waiting for the recording to start, and then we will start talking. I don't see the recording signs coming on yet. That's what I'm waiting for. Okay, I see one. We have one recording sign on. We'll go ahead and get started. All right, so good morning. I am Alan Lilly, the presiding hearing officer for the State Water Resources Control Board's Administrative Hearings Office. This hearing is being conducted by the Administrative Hearings Office on the administrative civil liability complaint that the State Water Board's Division of Water Rights Assistant Deputy Director filed on October 18, 2019 against James Simoni. When I refer to the AHO, which I will sometimes, I'm referring to the Administrative Hearings Office. And when I refer to ACL, which I also will do sometimes, I'm referring to administrative civil liability. Assisting me today from the Administrative Hearings Office are Skylar Anderson, Amy Blunk, and Nicole Mullen. And also we have assistance from Carol Berkeley of the State Water Board's Office of Chief Counsel. We are still learning how to conduct these Zoom hearings, so please be patient with us as we work through the logistics. It looks like currently some of the parties are on mute and some are not, so I will, let's go ahead and unmute. Let me just get appearances and we will unmute as appropriate. So first of all, for the Division of Water Rights prosecution team, who is appearing today?
Good morning, Mr. Lilly. This is John Prager. I'm an attorney in the Office of Enforcement representing the Division of Water Rights. I'm appearing today as assistant counsel to Mr. Lewis.
Okay, so Mr. Prager, will you be the lead attorney or will Mr. Lewis be the lead attorney for the prosecution team today?
It'll be Mr. Lewis.
Oh, okay. So Mr. Lewis, could speak now? I just want to make sure we can hear you.
Yes, good morning, Mr. Lilly.
Okay, and please either get a little closer to your microphone or you can click on the microphone icon, which I think will make it a little, you can have a setting where you can make it a little louder. So that would be good as well. I mean, we can hear you, but it's just not super.
Yeah, is that better, Mr. Lilly?
Yeah, that's a little better. Thank you. All right, then we will get your witnesses in a minute. So Mr. Simoni, I see you here. You might want to just tilt down your screen a little bit. We could just to get, yeah, there you go.
That way.
That's a little too far. I don't know if you have a monitor there. That's good. Now we can see you.
No, I don't have to have only an iPad. We don't have any other ability to respond in Zoom meetings yet. We have this is a new system to us completely.
Okay. Well, we can hear you and see you fine, so that won't be a problem. So other people, if you are just listening, you don't need to identify yourself. This is a public proceeding, and anybody is allowed to listen in, just the way people could sit in the audience if we were in a hearing room. But is there anybody else who would like to make any statements today during the course of the hearing that I need to know to recognize now? Okay, not hearing no one else, we will go ahead and proceed then. First of all, just a couple of preliminary process points. I will call on people to speak. And if I've unmuted you, it's if you can remember to stay on mute, although I don't have any feedback problems now. So if there are feedback problems, I may ask some of you to go on mute when you're not speaking. But right now, I don't see a problem. And if you want to say something and you can't, oops, let me just shift over here. I'm going to try to keep the participants link open so I can see your hand raised. Well, actually, I can't do that because it goes right in the middle of the screen. But if you want to raise your hand, you can do it the old-fashioned way, and we'll know that you want to speak. And if you need to, just speak up. We do the best we can. It's not as quite as easy as having an in-person hearing, but we'll do what we can. Hopefully, we can make sure everyone gets heard when necessary. This is not a court proceeding, so please do not say Your Honor. But we do like to keep it somewhat formal, so I ask you to all refer to each other by Mr. or Ms. Looks like all Misters today, and we'll proceed that way. So if necessary, I will ask you to identify yourself, although frankly, with the Zoom meeting, it's usually pretty clear who's speaking. Nicole Mullen of my office is very good at organizing our exhibits, and anytime you need to have any exhibit placed on the screen to display, she can do that. That certainly makes it easier when you want to ask a witness questions about an exhibit. We are recording this proceeding electronically. We will post after the proceeding a video plus audio file and an audio only file on the AHO's FTP site. We do not have a court reporter. Okay, so the prosecution team has the burden of proof in this matter. So the prosecution team will go first. And before the witness, it looks like it's just one witness for the prosecution team, I will administer the oath. And then after that, the respondent may ask the prosecution team witness cross-examination questions. Doesn't have to, but may. And then after that, we will follow up. I will ask questions, and then there can be redirect questions from the prosecution team's attorney. After that, then the respondent, I will administer the oath to the respondent, and he may testify, and then the prosecution's team may cross-examine that witness, and I may ask questions, and there can be follow-up, redirect if necessary. Mr. Simoni, you're an attorney, so obviously you're familiar with these proceedings. It looks like you have a question, so please go ahead.
When do you get to make a motion to dismiss?
Okay, let's talk about that. Let me go through this. And I was going to allow short opening statements, so if that would be the appropriate time to do that. I don't normally have opening statements, but we certainly can today, and that probably would be a good idea. So I will ask Mr. Lewis to first make an opening statement if he wants to. He does not have to. And then Mr. Simoni, you may do that and state any motions. And of course, Mr. Lewis, you may state any motions as well. After we finish all of the evidence, I will ask for closing arguments, and we'll see if there are any other process matters that need to be addressed. When the matter is deemed submitted, my colleagues and I will prepare a proposed order, which by law we must complete within 90 days. And then as stated in the hearing notice, we prepare a proposed order under Water Code section 1114 subdivision C, and then we transmit the proposed order to the clerk of the board for consideration by the 5 board members. And when we do that transmittal of the proposed order, we will send copies to all of you and also to everyone else who has signed up to receive AHO emails. And we also will post the proposed order on the AHO's web pages. So you did have one question, which I think I've answered, Mr. Simoni, but are there any other questions about process before we proceed with the hearing? Yes, Mr. Lewis.
Mr. Lilly, the prosecution team for the recording would like to lodge its formal objection to this hearing that was submitted to AHO on July 14th.
Okay, go. Well, you can do that as part of your opening statement. So let me just get to that. I think we're there soon, so just bear with me. Are there any other procedural questions? Then, All right, then Mr. Lewis, go ahead and you may make motions, objections, and opening statement now. And then Mr. Simoni, you may make opening statements, objections now, and then we'll proceed with testimony. So excuse me, Mr. Lewis, but please go ahead now.
No, thank you, Mr. Lilly. The unpredictable and dynamic nature of AHO's procedural adjustments have led to workload associated conflicts within the Division of Water Rights. The need for clear rules and expectations when it comes to hearing process is necessary. And it was for these reasons that the prosecution team formally objected to this hearing on July 14th. And we would like to have this formal objection noted for the record.
All right, and your July 14, or excuse me, the July 14 letter from Ms. Rizzardo has been added as part of the record. That's part of the record that's posted on the AHO FTP site. And we're going to proceed with the hearing today, but certainly my colleagues and I will consider the objections that were stated in that letter and the objections you stated today during our process of preparing the proposed order. So your objections clearly are stated. I'll just say there are challenges in the COVID-19 era with communications back and forth. Email is not 100%, but the bigger problem by far is that mail is much slower. Both the US mail is much slower, and then getting envelopes from delivery to the water board or to the Cal EPA building to our office is much slower. So that, I think, I'll just say that's by far the biggest problem I've encountered, and that's why there have been some changes in scheduling and procedures. We're just not getting things as fast as we used to. But anyway, your objections are noted, and as I say, certainly will be considered during our deliberative process. And would you like to make any opening statement today, or do you want to just proceed with testimony after Mr. Simoni's objections?
Yes, Mr. Lilly, I would like to make an opening statement today.
Okay, please go ahead and do that now.
Thank you. We're here today because Mr. Simoni failed to timely file a supplemental statement of water diversion and use for the 2018 water year. The California Constitution in Article 10, Section 2, sets forth the policy that the conservation of the state's water resources is to be exercised with a view to the reasonable and beneficial use of the resource in the interest of the people and for the public welfare. The legislature and the State Water Resources Control Board are authorized to enact laws in furtherance of this policy. Pursuant to this authority and in furtherance of this policy, both the legislature and the State Water Board enacted laws and regulations requiring the annual reporting of water diversion and use. The regulated community, water right and statement holders, timely submission of annual reports of water diversion and use provides the Division of Water Rights with critical information that allows the State Water Board to implement this policy. The Division of Water Rights prosecution team recommends an administrative civil liability penalty in the amount of $2,000 for Mr. Simoni's failure to timely submit this requisite report. With that said,
Go ahead. I thought you were done.
With
Please
that
go
said,
ahead.
I would like to call my first witness, Mr. Allen. Mr.
Okay,
Lilly.
but first, before we do that, I'm going to allow Mr. Simoni to, I think he said he wanted to make a motion, and also if Mr. Simoni, if you want to do any opening statement, you may do so now, or if you want, you can wait and do that when you put on the beginning of your case. But you did say you wanted to make the motion, so now's the time to do that.
Thank you, Your Honor. This is an opening statement. It's not time for Mr. Lewis to call witnesses. In my opening statement and my motion, I'd like to point out first that the civil complaint should be dismissed because it is constitutionally invalid, as the system that requires reporting does not require them statutorily to bring a notice of the need to report before the deadline for reporting. I'd like to point out that besides that, the deadline for reporting occurs at a time of year when rural landowners and water producers are at the busiest time of the year. The appropriative rights reporting is done in the wintertime, when in fact there might be some time when you're not busy with equipment and taking care of a property to do your reporting. We have faithfully reported every year, the constitutional invalidity is on its face because it does not have any type of a system requiring the State Water Board to give us notice of reporting. Now, when there was a paper system, this happened automatically because you got the paper in the mail with the request to fill it out. And in fact, if you understood what you were doing, at least on the appropriative side, you could fill out the report and send it back. The only, constitutionally, the only valid question that the State Water Board can ask is, what did you do with the water? It doesn't require all this myriad of reporting by month and all of that I see in some of these reports. Now, when you're dealing with the riparian system, that is especially true because the riparian system is a self-enforcing system. If in fact there is water in the creek, then the landowner beside the creek can draw as much water for his beneficial use. He can't water chamise, but if he is irrigating land, if he is watering cattle and livestock, he is entitled to use whatever amount of water he is used. This has already been decided in this case, in the case of Simoni versus Mellon, which is, I cited in my mail, which I would like to ask at the closing of my statement, whether everyone received it, because we sent it by U.S. Priority mail and also by email in hopes that all the parties would have it. So that is the first reason that it is a self-enforcing system, and there is no need for judicial, this kind of extreme oversight. It is an attempt to take by regulation. The second reason it is a violative of the Constitution is that the form itself requires, the electronic form, not the paper form, that was fine, but the electronic form requires you to give answers that they determine you can give. And then if you don't give those answers or refuse to answer for any specific reason, it doesn't give you a good space to state your objections. And in fact, the first forms I saw required that these matters be submitted under penalty of perjury, which means that they required you to testify to falsity before, so you could file the form. This creates a system totally lacking in due process, and actually an Orwellian scenario which punishes you for not telling a lie. The third reason, well, I've already stated that. The third reason that the only viable question that the Water Board can ask is, are you using this for beneficial use? Now, what happens if you don't use the water? If you don't use the water, it goes down the creek. It's a self-enforcing system. Then the public has use of it farther down the creek. Now, in the water suit, Simoni versus Mellon, which was Santa Clara County Superior Court. I cannot see, where is my, I can't see my site on it right now, but I gave you the case number. And in that case,
and Mr. Simoni, just so you know, I did receive your July 21 letter. So, and I think it is cited in there. So I have that. It was sent by email. I don't think I've gotten the paper copy yet, but I did receive the email, and I've posted that, or my staff has posted that to the AHO website. So, Mr. Lewis, have you received the July 21 letter from Mr. Simoni?
Yes, we did receive his July 21 letter.
Okay, so we both have those, Mr. Simoni, if that helps you shorten your statement a little bit.
The rest of that in my open statement. The second reason that it's constitutionally invalid is as a chilling effect when someone's oversight and trying to record the amounts of water, and that so that they can in the future say, well, you don't get any more than that amount. That's why it has a chilling effect as well on constitutionality. The mail in the past has been sufficient, but that's not part of the opening statement. So that's my opening statement, Your Honor. As far as my motion goes, I believe, Your Honor, that you'll find as I produce my evidence that I tried many times to talk to the Water Board, and there's only so much time in an ordinary person's life with the few horses we have in comparison to the state of California for us to try and deal with these questions. I tried of over 20 years now to get a discussion with the State Water Board, and I have been basically given the finger and not wanting to. What they are doing now is issuing edicts on like rulers, telling us to comply and not telling us why or discussing why we should comply. This, which you will find in the evidence, may have been a mistake between a failure to understand or a simple mistake. Oops, maybe it's the wrong form. Because we can't tell when they're sending us things would have tens of thousands of words. We can't tell whether or not we are understanding what they're saying. As someone had simply called in 20 years and discussed this issue with us, this probably would have been laid to rest long time ago before civil complaints and all that. That's just totally unnecessary. All of it is totally unnecessary. That's my opening statement, Drew.
All right. So thank you. As I said to both of you, I'm not going to do any rulings on motions now, but I certainly will consider both of your arguments when I am working with my colleagues to prepare the proposed order. So with that, Mr. Lewis, you submitted Mr. Cervantes' declaration. Is he in fact your only witness who is going to be testifying at this hearing?
Yes, Mr. Lilly.
Okay, so Mr. Cervantes, if you can go off mute, we will go ahead and proceed with the question. So Mr. Cervantes, please raise your right hand. And you are off mute, good. Do you swear or affirm under penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. And Mr. Lewis, you have emailed copies of exhibits PT1 through PT11 to me and Mr. Simoni. I believe your emails indicate you included him as a CC. Is that correct?
You're correct.
And Mr. Simoni, did you receive the emails that Mr. Lewis sent on Wednesday with exhibits PT1 through 11? There were two separate emails.
Your Honor, I'm not seeing it here in my file. I will look here in the email and see if it came through.
Well, okay, excuse me, go ahead.
Was this in 7/22/2020?
Yes, that would be Wednesday.
I see it here. I see 8 attachments.
Okay.
Plethora, pardon me for saying so.
Okay, so you've at least received the emails. And Mr. Lewis, did you also mail paper copies to Mr. Simoni?
Yes, via first class mail as directed by the updated service list.
Okay, so Mr. Simoni, if they mailed those on Wednesday, you probably have not received those yet, but you will. Hopefully someday. That's, as I mentioned, I know that my experience is the mail service is slow, but it comes through. All right, well, in any event, Mr. Lewis, ask my office, Nicole Mullen of my office, to post the pages you want Mr. Cervantes to talk about. That'll make it a little easier for all of us to follow, frankly. I noticed you do have a hearing presentation exhibit PT9, so I assume you want to post that, but just ask us which exhibits you want to post and we'll post them so everyone can see them, and yes, then Mr. Cervantes may proceed.
Can you please post prosecution team exhibit number 9, hearing presentation?
Okay, and she'll get to it. Just give her a moment. Okay, so we now have on the screen exhibit PT9, slide 1, and you may proceed with your questions, Mr. Lewis, of Mr. Cervantes.
Yes, Mr. Cervantes, floor is yours. Can you please present the hearing presentation?
Yes, I can. All right. Good morning, Mr. Lilly. My name is Robert Cervantes, My testimony today supports the State Water Resources Control Board Division of Water Rights recommendation to issue an administrative civil liability order against the respondent, Mr. James V. Simoni. I am the program manager of the Water Rights Enforcement Section and a licensed professional engineer. I have over 18 years of technical and regulatory experience related to water resource issues. I have been the Water Rights Enforcement Program Manager for 11 months. Slide 2, please. California Code of Regulations, Title 23, Section 920, requires persons who filed an initial statement of water diversion and use pursuant to Water Code 5101 to file supplemental statement of water diversion and use reports annually before July 1st. We call the supplemental statements annual statements for short. Annual statements must be filed electronically by July 1st using our online report management system. Failure to file an annual statement by July 1st violates the regulation. Information included in the annual statement is critical for administering water rights and managing the state's water resources. Timely submission of this information allows the State Water Board and the public to know when, where, and how water is being used, plan for drought, and ensure water is being put to beneficial use. The failure to file enforcement program helps ensure that diverters provide this information through a progressive enforcement strategy using education, outreach, and if necessary, formal enforcement. Slide 3, please. ERIMS identifies the respondent as the primary owner of statement S-486. Therefore, the respondent was required to file an annual statement pursuant to Title 23, Section 920 of the California Code of Regulations. The respondent failed to file the annual statement by the deadline, violating the regulation. Ultimately, after extensive research and an ACL complaint, the respondent filed the annual statement on June 9, 2020, 344 days after the deadline. Slide 4, please. This is Prosecution Team Exhibit 4, the ERIMS database query identifying the respondent as the primary owner of the statement of diversion and use. The personally identifiable information of the respondent is redacted to prevent public disclosure. These documents show the respondent as the primary owner of statement S-486 as of April 23, 2006. Slide 5, please. This is Prosecution Team Exhibit 4. On the left is an annual statement for statement S-486 from the years 2006, 2007, and 2008. On the right is the statement for S-486 from the year 1936. Personally identifying information is redacted. Slide 6, please. This is Prosecution Team Exhibit 8, the ERIMS query showing the dates the respondent filed annual reports for the applicable statement. The query shows the respondent filed the 2018 report on June 9th, 2020. Slide 7, please. This is a continuation of Slide 6, PT Exhibit 8. The query shows ERIMS reporting dates for years 2009 through 2013. The respondent filed annual statements online starting on August 3rd, 2018 for the 2009 reporting period. Slide 8, please. The Division of Water Rights Enforcement section ensures the regulated community complies with water right laws and regulations. The purpose of the failure to file enforcement project is to achieve this goal for annual reporting regulations through compliance assistance and progressive enforcement. Slide 9, please. The division is not statutorily obligated to notify diverters of their annual reporting requirements. That being said, staff attempted to notify the regulated community on 4 separate occasions prior to issuing the ACL complaint. The Enforcement Section and Data Management Unit started collaborating in early January 2019 to notify diverters of the reporting requirement and provide compliance assistance. Staff hosted a water measurement workshop on January 18th, 2019 to give the regulated community an opportunity to ask questions and file reports in person. In addition, staff mailed notification letters to primary owners and agents reminding them of the deadline on February 15th, 2019 and August 30th of 2019. We sent notification through email on June 18th, 2019. Finally, the division issued the ACL complaint with an option for expedited settlement on October 18th, 2019. The next 2 slides depict some of the division's work to notify the regulated community of the requirement to file annual statements, assistance in fulfilling the requirement, and outreach to compel compliance after the reporting deadline. Slide 10, please. This is Prosecution Team Exhibit 2, a copy of the February 15th, 2019 letter mailed to the respondent at the address of record associated with the statement in ERIMS. This letter informed the respondent of the requirement to file the annual statement by July 1st deadline, provided instructions on how to file the annual statement, and warned of potential penalties if the annual statement was not filed by the deadline. Slide 11, please. Before the July 1st deadline, division staff provided additional notice concerning the filing deadline using the State Water Board's listserv email account. We refer to it as LIRIS. The left half of this slide shows Prosecution Team Exhibit 3, the LIRIS email we sent to all subscribers on June 18, 2019, reminding them to file the requisite annual statement before the deadline and warned of potential penalties for entities that failed to file the reports before the deadline. After the filing deadline to submit annual statements passed, division staff monitored ERIMS for compliance and issued notices to the primary owner or agent that failed to file annual statements. Exhibit 5, the right half of this slide, shows a letter entitled Final Warning, Notice of Deficiency. It was a final warning mailed to the respondent's address of record. This notice, dated August 30, 2019, informed the respondent that the annual statement reporting was still deficient, explained that the division was prepared to issue an administrative civil liability complaint for their failure to file, and provided instructions on how the respondent could avoid potential penalty. Slide 12, please. In determining the proposed penalty pursuant to Water Code Section 1055.3, the prosecution team considered the harm caused by the violations, the nature and persistence of the violations, the duration of the violations, the respondent's corrective actions, and all other relevant circumstances. I will discuss each of these factors in turn. Let's start with the harm caused by the violation. Respondents' violations harm the orderly and efficient administration of the state's water resources. This in turn impacts other water right diverters, the environment, and the public at large. As previously mentioned, the information the regulated community includes in the annual statements is critical for administering water rights and managing water supply. Without clear and timely understanding of who is using water, where, and how much is being diverted, and when that water is being diverted, the Water Board is limited in its ability to perform the following 7 essential functions. Number 1, issue accurate permits or grant petitions. Number 2, determine availability of water and likelihood a diversion may cause harm. Number 3, conduct timely and accurate billing for water use. Number 4, conduct fair, efficient, and accurate drop planning and measurement. 5, develop in-stream flow requirements and protect public trust resources. 6, build and calibrate water availability models. 7, respond to and evaluate complaints of unauthorized diversions. Cumulatively, these types of water diversion and use reporting violations undermine the validity and transparency of the water rights system. Now let's talk about nature and persistence of the violation. As detailed in the presentation, the division conducted extensive compliance assistance and outreach to the regulated community to ensure compliance with the reporting requirements. This included a workshop, an email reminder, a letter reminder, and a notice of deficiency warning of imminent ACLCs. Notwithstanding, respondent failed to file the deficient annual statement. It was only after significant resources were expended in an effort to compel compliance that the respondent finally submitted the annual statement 344 days after the filing deadline. Now let's discuss the duration of the violation. The value of the data and information included in the annual statement for inclusion in water availability forecasting is diminished when not obtained on time. As such, every annual statement that is not filed by the deadline contributes to water resource modeling uncertainty and inaccuracy. Moreover, the length of time over which the respondent's violation persisted, despite repeated attempts to notice the failure to file, is significant. Next, I'll talk about the diverter's corrective action. On June 9, 2020, respondent filed the deficient annual statement. This is 344 days after the deadline. Considering the outreach performed by division staff to compel compliance, the respondent's late filing is not a reasonable and prudent response to the violations. As such, the respondent's corrective action does not merit a reduction in the proposed penalty. Other considerations. As part of the division's progressive enforcement strategy, the respondent was encouraged to settle the alleged violation. The division proposed a 3-part settlement offer to the respondent. This included paying a reduced liability of $500, filing the delinquent report, and signing a waiver of the right to hearing. The settlement amounts to 1 day of violation, which is a 99% discount of the potential maximum liability the respondent may incur for the violations. The settlement amount is low enough to encourage voluntary corrective action, but still high enough to encourage voluntary compliance in the future. The respondent rejected this offer. In contrast, the proposed penalty, $2,000, represents 4 days of violation. The exact amount of resources spent by staff were not calculated for this specific case. While quantifying the number of hours spent on a specific case is difficult, staff were able to calculate the total number of hours spent on the failure to file project. Over the course of approximately 11 months, the failure to file project required the involvement of 8 employees and approximately 286 hours to conduct outreach, monitor voluntary compliance, and compel compliance with the reporting requirements. The division believes the proposed penalty is the minimum amount to reasonably deter future violations while accounting for resources spent by the water board staff compelling the diverter to file their requisite annual statement. We further believe it is the minimum amount that encourages voluntary compliance through the settlement offer. Slide 13, please.
Okay.
On October 18, 2019, With the respondent's annual statement still deficient, the division staff issued an ACLC to the respondent for violations of Title 23, Section 920 of the California Code of Regulations with a recommended penalty of $2,000. Thank you for your time. I'm now open to questions.
All right, Mr. Simoni, you may ask cross-examination questions of Mr. Cervantes now. As a reminder, and I know you're a lawyer, so this is probably obvious to you, but you will have an opportunity to testify later. So this is now the time for cross-examination questions. And if you want Nicole Mullen to put up any of the slides Mr. Cervantes referred to during your cross-examination questions, please just let us know and she will be glad to do that.
At what time during all of this process, Mr. Cervantes, did you call the diverter and ask him why he failed to file?
My understanding is that we did not call the diverter to inform him that he failed to file. We reached out multiple times, as noted in my testimony, via US mail, email, and in person through a workshop. And it's important to note at this time that we're not statutorily.
This is not answering the question, Your Honor.
And Mr. Simoni, please don't call me Your Honor. I'm not a judge, but if you can just call me Mr. Lilly, that's fine. And I think he did answer the question. I think now he's perhaps going past that. So Mr. Cervantes, why don't you hold up now unless Mr. Mr. Simoni ask another question.
So at no time did you ever call the diverter to determine why it wasn't filed?
Objection. Asked and answered.
No, I overrule the objection. This is a different question. This is bringing in the why rather than simply whether or not a call was made. Mr. Cervantes, you may answer.
Mr. Simoni, would you please repeat your question?
The question is, when did you call to ask the diverter why it was not filed?
So your question is, when did we call? We did not.
Did you ever consider, which is a different question again, of calling the diverter to determine why it was not filed?
No.
Does your staff read the statements filed by the diverters?
Sometimes. Oftentimes, no.
What is the use being put to the information when it's not read?
Let me correct my answer. We analyze statement data through our computer ERIMS system. So we do compile the information submitted by the diverters in their statements annually.
Please look at slide number 5.
Okay, and hold on just a minute, Mr. Cervantes. Let's put up slide 5 so we all have it in front of us. And then then Mr. Simoni, I assume you'll have a question, but let's get slide 5 up first. Okay, we now have slide 5 from exhibit PT 9 on the screen. Please ask your question.
Mr. Cervantes, do you see where it wrote in answering the question, 150 acre feet?
And Mr. Simoni, it'd probably be good if you clarified whether you're referring to the table on the left or the table on the right on this slide with your question.
Well, the table on the left page, which is below the table that states the years 2006, 2007, it asks in section D, I believe, because it's hard for me to read, the quantity of water used.
Okay, so then what is your question regarding that?
The question is, do you see where it was stated at 150 acre feet?
Yes.
Okay. Did your staff, if they read this, realize and compare it to the other water use being made by this diverter under his appropriative right?
I don't know. This is far before my time in water rights. Oftentimes, we do make a comparison between diverters that report under both appropriative and riparian.
In your experience, if in fact someone reports in a supplemental use the amount that's being used in the appropriative right, don't you think, in your opinion, that that would indicate that someone is confused?
Objection calls for a legal conclusion.
It does not. I will object.
Mr. Cervantes is not a lawyer, but he clearly has expertise in this area of the law. So I'm going to overrule the objection and allow the question to go forward. Mr. Cervantes, answer to the best you can. And if you need to qualify the limitations on your legal knowledge when you answer, please do so.
Okay, Mr. Simoni, would you please repeat your question?
The question is, in your experience, if you see that an appropriative water right, if you see in a supplemental form that the amount reported used is the same as the amount allowed in the appropriative water right, wouldn't that give rise to an indication and evidence that the diverter is confused?
You know, answering as an engineer and the program manager, maybe I see that perhaps they could be, a diverter could use the same amount in their statement under their riparian and their report under their appropriative. However, what we found is that what we would look for is double counting of diversions. So to answer your question, maybe.
We could take the form down, Mr.
Okay,
Lilly.
if do you want to put up any other slides right now?
I don't think so.
Okay, well, we'll go ahead and take that one down then. Thank you. And let us know if you want us to put up another slide later, we'll be glad to do so.
Thank you. Let me think what else. I have to think on my feet here.
Okay, well, just take your time.
Let's see. Did you ever make an attempt to individually contact by mail the diverter, myself, in other words?
Can you clarify what you mean by individually contact you? Can you clarify that?
In other words, sending a letter specifically designed to the diverter so that he would answer, his questions would be answered.
No.
Okay. That's all the questions I have at this time, Your Honor. Excuse me,
Okay.
Mr. Lilly.
Thank you, Mr. Simoni. And I just have a couple of follow-up questions. If we can, Nicole, please put up Exhibit PT 11, which is the Cervantes Declaration. Just a minute, she has to pull that file. It might take a minute, it's a big file. And then just so you know, Mr. Cervantes, I'm going to be referring to page 3 on that. I assume you have your own copy of your declaration.
Thanks.
Okay, so then we'll go to page 3. And then thank you, Nicole. And if you need to have it be made bigger, we can, although we can't get the whole page on the screen if we make it bigger. And you probably have your own copy, Mr. Cervantes. So my question is beginning at line 13, the text states, in addition, DMU staff mailed letters to all water right holders on February 15, 2019, reminding them of the pending filing deadline for annual statements, July 1, 2019. The letters were mailed to the address listed for the primary owner and/or agent of record for each water right as identified in ERIMS. A true and correct copy of the letter mailed to the diverter is offered into evidence as prosecution team exhibit PT2. And I think you had a copy of PT2 in your slides, but Mr. Cervantes, do you see that testimony?
I do, yes.
And was that letter sent by certified mail or first class mail?
First class mail.
Okay, does the Division of Water Rights maintain records of first class mail envelopes for notices like these that are mailed and then returned by the Postal Service?
Yes, we do.
Does the Division of Water Rights have any record that the envelope with the letter that is exhibit PT2 was returned to the division as undeliverable?
We don't believe it was returned to us as undeliverable.
Okay, now I'm going to go forward to line 17 on that same page, same exhibit PT11. And I'll just read the text here. Lastly, division staff issued an email to 6,586 water rights reporting LIRIS subscribers on June 18, 2019, reminding them of the July 1, 2019 deadline for statement holders to file annual statements. A true and correct copy of the division's email is offered into evidence. That's prosecution team exhibit PT3. Do you see that testimony?
Yes, I do.
And does the Division of Water Rights have any record that a copy of this email was emailed to Mr. Simoni?
Not specifically, no.
And now if you can, Nicole, please move to page 4 of exhibit PT11. And I'm going to go down to line 13, and I'll just read it here. This is referring to the August 30, 2019 notice of deficiency. And at line 13, your testimony states, the notice of deficiency was mailed to the primary owner or agent for specific water rights or statements. A true and correct copy of the notice of deficiency mailed to the diverter at the diverter's address of record is offered into evidence as prosecution team exhibit PT5. Do you see that?
Yes, I do.
And I think one of your slides that you showed had that. So a copy of that exhibit. And I think you said before that the Division of Water Rights maintains records of first class mail. Well, first of all, let me ask, was this letter sent by first class mail or certified mail?
First class.
Okay, and I think you said that the division maintains records of first class mail envelopes returned by the Postal Service. Is that correct?
That's correct.
Does the division have any record that the envelope with the letter that is exhibit PT5 was returned by the Postal Service as undeliverable?
No, we didn't receive an envelope back as undeliverable.
Okay, that concludes my questions of Mr. Cervantes. So we will first go to Mr. Lewis. Do you have any redirect questions based on either within the scope of either Mr. Simoni's cross-examination or my questions?
Mr. Lilly, I have one more question if you don't mind.
I'm going to give you a chance to do recross after Mr. Lewis does his redirect.
Thank you.
So bear with me one at a time, but Mr.
That's
Lewis, redirect for you next.
Yes. Thank you, Mr. Lilly. Mr. Cervantes, is the division required to call diverters when they fail to file their requisite reports?
No.
Thank you. Is the division required to verify all information submitted in a diverter's annual report?
No.
In your estimation, how many annual statements or annual reports does the division receive annually?
So annually, we receive approximately 18,000 statements. This past year, approximately 12,500 statement holders reported on time. So that's about a 70% success rate of riparian diverters reporting on time.
Mr. Lilly, can you please have Ms. Mullen pull up Prosecution Team Exhibit 2.
Yes, she will do that.
Thank you. Mr. Cervantes, do you recognize this letter?
Yes, I do.
What is this letter?
This letter is a notification reminder letter to water right holders, diverters that we send out every year. So it's a reminder.
And to whom is it directed?
This letter is directed to James V. Simoni.
And where did you obtain this address?
This is the address of record that Mr. Simoni provided to us, and it's in our ERIMS database.
And can I please ask you to read aloud the last line of Prosecution Team Exhibit 2?
Yeah, can you zoom in, Ms. Mullen? It's really
Yeah,
small.
she can maybe make it bigger and then just scroll down to the last part. That's fine.
That's good. Yeah, just scroll down, please.
Okay.
All right, the last line. If you have questions or concerns, please contact the Division of Water Rights by email at rms@waterboards.ca.gov or by phone at 916-341-5431.
Mr. Lilly, can you please ask Ms. Mullen to bring up Prosecution Team Exhibit 5?
Yeah, and you can just ask Ms. Mullen to do that. That's fine. If all you're asking is putting up exhibits, it's fair game for you to ask her to put up any exhibits. So now I think we have, is this PT? We now have exhibit PT5 on the screen. And let us know whether you want full screen mode or zoom in and scroll down.
Okay, thank you. Mr. Cervantes, do you recognize this document?
Yes, I do.
What is this document?
This is the notice of deficiency that we send to diverters after the deadline has passed. So this is like a final warning, notifying diverters that we're about to take enforcement action.
And to whom is it addressed?
Ms. Mullen, would you please scroll up? This letter is addressed to James V. Simoni.
Great. And can you please read the last line of Prosecution Team Exhibit 5?
Yes. If you have questions or concerns, please leave a message with the Division Enforcement Section at 916-341-5342 or by email at dwrreporting@waterboards.ca.gov. Division staff will contact you shortly.
Thank you. And does the division staff these lines, these phone numbers?
Yes.
Does the division have a procedure for documenting calls to these numbers?
Yes, we do. Yeah, all staff is trained on call log procedures.
Do your phone logs show Mr. Simoni contacting these numbers?
I believe we have one contact from Mr. Simoni on June 15th of 2020.
And based on your expertise as program manager, does division staff adhere to these procedures to log calls?
Yes, to my knowledge, they do.
Thank you, Mr. Cervantes.
Thank you.
Does that complete your redirect, Mr. Lewis?
Yes, Mr. Lilly.
All right, so Mr. Simoni, recross obviously limited to the scope of what has been covered in either my questions or Mr. Lewis's redirect questions. Please proceed.
Mr. Cervantes, looking at PT5, since it is on the screen, show me where in this exhibit it specifies which water right is being discussed.
And if you need to, you can ask Ms. Mullen to scroll up or down or get it so you can see the whole page, because I don't think we have quite the whole page on right now.
Yeah, sure. Ms. Mullen, would you please scroll up? All right, yeah, perfect. That's good. Okay, so it looks like there's two sides to this, or two pages to this letter, and the portion of this letter that's not shown describes the water rights that it's referring to.
Is that second page in Exhibit PT5? If so, we can scroll to it.
Yep, there it is.
There. Now we have the second page of PT5 on the screen.
And where does it say that is a riparian right?
It doesn't explicitly say it's a riparian right, but all statements that begin with S, a water right number ID of S is riparian or pre-14.
And how, Mr. Cervantes, would the diverter know that?
We would hope that diverters know what their water right ID is.
In PT2, could you please show me where the water right is described?
Okay, let's put up, Ms. Mullen, please put up PT2. First, bear with us, Mr. Simoni. We go as fast as we can here electronically.
And Mr. Lilly.
Okay, and if necessary, we can go to page 2 of this one as well. Okay, which do you want, Mr. Simoni, page 1 or page 2 of PT2 on the screen?
I think we can start with page 1. Please show me, Mr. Cervantes, where the water right is described in this letter.
All right, Ms. Mullen, would you please zoom in? Okay, so this is a reminder letter for all water right holders. So the first page of the letter doesn't describe specifically what water right we're referring to. Page 2 provides each diverter with their water right ID number.
Can you point that out, please?
Yes.
We'll go to page 2 now. All right, there. Now we have, whoops. Now we have page 2 on the screen of Exhibit PT2.
And
So
where does
Mr.
it
Cervantes,
describe,
you may proceed.
and where on page 2 does it describe that it's a riparian right?
Page 2 provides the water right ID with the statement number starting with the letter S.
Yes, but it doesn't describe that it's a riparian right, does it?
Not explicitly.
And it's not on the first page, is it?
No.
Now, Mr. Lilly, I'd like to have Mr. Cervantes, since he discussed phone calls, look at my November 19th letter. Is there any way to put that on the screen?
I think so, but bear with us. So
Sure.
Ms. Mullen, we'll have to see. I don't think either party has offered that as an exhibit, but it should be in our administrative record. So we can go to the FTP site and hopefully she can pull that up. That would be, and actually there's another way we can do it. Let's see if we can find it that way. I think you did attach it as an exhibit to one of your subsequent letters, but let's just see if we can find it that way first.
I know there is a PDF version attached to my July 22nd letter, I believe.
Yeah, let's do that. Ms. Mullen, can you find the July 21, 2020 letter from Mr. Simoni to the State Water Board, please? And put that up on the screen. And then you're right, Mr. Simoni, it looks like that will be Exhibit D. That's good. Okay, so scroll down and we'll try to get to Exhibit D to Mr. Simoni's July 21, 2020 letter to the State Water Board and others. Bear with us, we'll go down, it's a few pages. Okay, so there's the cover page for Exhibit D. And now we'll go to the next. This is the first page of Mr. Simoni's November 19, 2019 letter to the State Water Resources Control Board, Administrative Hearings Office. So we now have that up on the screen. So Mr. Simoni, you may now ask Mr. Cervantes your question.
You testified that you had sent a letter early in 2019, which I believe was described as PT2 or PT5, and to me. Now, when did the Division of Water Rights respond to my November 19th, 2019 letter, which states there that I've called many times and no one has returned my calls? When did they respond?
Objection. This is outside the scope of Mr. Lewis's redirect examination of Mr. Cervantes. Discussions.
I'm going to overrule the objection. I think it's within the general scope of the questions about the division's responsiveness to diverters filing statements. So, Mr. Cervantes, you may answer if you have personal knowledge.
Okay, I don't have personal knowledge of division staff responding specifically to this letter of November 19th.
And I'm sorry if I restricted your answer too much, Mr. Cervantes. Mr. Simoni, I apologize. You can also answer the question if you have any knowledge based on your understanding of the practices of Division of Water Rights staff. And I apologize. I think I inadvertently narrowed Mr. Simoni's question. So just tell us what you know, and obviously only what you know, but based on your personal knowledge or your experience supervising Division of Water Rights staff in response to Mr. Simoni's question as to whether or not anyone from the division ever responded to this letter.
I don't know if anybody responded to this letter.
All right, Mr. Simoni, you may proceed.
I think that's my last question, Your Honor.
Okay, thank you. All right, just a moment here. I've got a few different papers here. I have to go back to my notes here. All right, well, that concludes the questions for Mr. Cervantes. Mr. Cervantes, thank you very much for testifying this morning. So Mr. Lewis, at this point, would you like to offer the prosecution team exhibits into evidence?
Yes, Mr. Lilly. The prosecution team would like to offer PT1 through PT11 into evidence.
All right, and Mr. Simoni, do you have any objections to these exhibits coming into evidence?
Your Honor, I have objections in that I believe that they are hearsay and that they violate, the exhibits themselves violate my Sixth Amendment right to confront my accusers. I don't believe that Mr. Cervantes' testimony covers everything that is contained in those exhibits.
All right. So what I will do is I'm going to admit exhibits PT1 through PT11 into evidence, but with the recognition that Government Code Section 11513 applies to the Administrative Hearings Office treatment of hearsay evidence to which objections have been made. And to paraphrase, it basically says such evidence may be used to support other evidence, but there are some limitations. I'm not going to try to read it. I've got the book here, but I don't think I need to. But anyway, the exhibits are admitted, but Mr. Simoni's objection is to the hearsay content is noted, and we will therefore limit the use of any hearsay evidence in those objections as provided in Government Code Section 11513. Mr. Simoni, your Sixth Amendment right argument also is noted, and we can consider that when we are considering the weight to give to these exhibits. So with that, we may proceed. Mr. Simoni, are you ready to testify this morning?
I am.
All right, so please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
All right, and you may proceed. And I forgot to keep the clock going, but I think Mr. Cervantes' direct was somewhere between 20 and 30 minutes. And I'm not going to try to be extremely strict, but I hope you can complete your testimony within that same time frame. I'll say approximately 30 minutes total. And we will be glad to put up, Ms. Mullen, we'll be glad to put up your July 22nd letter, and it had exhibits A through E, and we're glad to put up any of those if you would like to use those to illustrate your testimony. So please just let us know and you may proceed.
Thank you very much, Your Honor, Mr. Lilly. I first had difficulty with these reports as we are running a busy ranch and it's hard to keep it going at any time. Right now, we have 2 tractors down. We have a water tank that needs to be filled. And in fact, we are very stressed as far as being able to function as a ranch. The water is essential to us. The riparian water, as I explained earlier, in my understanding, is a system that is self-enforcing. We have litigated this system once, like I said, in systems with neighbors, and it is now a regulated stream section by Simoni versus Mellon in the Superior Court of Santa Clara County. When in fact the water gets, oh, there it is. It's Superior Court case number 121636, R. Simoni and Della Simoni versus Oscar A. Mellon. A water master has been appointed in that proceeding. If in fact the stream flow falls below a certain volume, then a rotation schedule is put in effect. I believe that there was a report made at the time by the Department of Water Resources. They're fully knowledgeable of it. They should have been knowledgeable of it in this case. I have been trying to ask questions of the Department of Water Resources for over 20 years. I have gotten no responses that are responsive. I have been not able to talk to anyone. This is the first time that I've been able to talk to someone who would give me answers. Now, I wrote letters. And if you look at Exhibit A, I first questioned the board back in 1994 that here's my water diversion and use. I assume this was sent to us in error. Okay. So what I want you to understand is that when this form was being looked at in what little time we have to manage the ranch, we were confused as to why this diversion was taking place. I got no response to this letter. Okay. So I wrote again, okay, on July 24th. And I again asked, and this is in 1995. Okay. And in fact, I asked again, I said, what is this confusion? Why am I responding and reporting on a form for the Uvis Creek, which is already taken care of? It's a riparian use. And I submitted my response. I submitted the form, always trying to comply. Okay. But then what kind of a response did I get? I did get a response to this letter, but it's the only response I've gotten in 20 years. And unfortunately, I could not submit it as an exhibit because I don't have a color capability. But if you will see in our file, now I saved these documents from records of the family, okay, because I was afraid of the bureaucracy I was dealing with because they were non-responsive. Please look at this. This is my letter sent back to me. It is given with red marks on it. There is no text. At most, in the lower right-hand side, it says, here's some stuff for you to read. Okay,
Objection. This,
that is it.
Wait, excuse me, Mr. Simoni. Mr. Lewis, would you like to state your objection, please?
yes, the letter that Mr. Simoni is showing on the screen with the notes was not introduced into the exhibits. As such, the prosecution team has no knowledge of these and is neither prepared to ask questions regarding them.
Okay, and this is a little tricky because we're doing this hearing by teleconference. The hearing notice did not require the pre-submittal of exhibits. There was optional, and I certainly encourage the parties to because it helped make our logistics go better. He was not required to submit it ahead of time. However, that doesn't take care of your concern that you can't see it now. And Mr. Simoni has said he didn't have any way to scan it and send it to you. I'm just wondering, I'm going to ask Skylar Anderson, Mr. Anderson of my staff, if you can go to eRIMS and see, pull up the eRIMS file for statement S000486 and see if a copy of this letter is there. If that is, we can get it up on the screen and cut through this concern. Because Mr. Lewis, you raised a legitimate concern, but on the other hand, Mr. Simoni does have a right to testify about this. So let's see if we can do that. And then if not, we'll have to figure out another way to deal with this.
Mr.
Lewis, go ahead.
The prosecution team also objects to this, as these are letters from 1994 that are irrelevant to the question at fact in this hearing.
Okay.
That's whether he failed to timely file a report, not whether he's been trying to communicate with the water board since 1994.
Okay, and that objection I'm going to overrule because as you've pointed out, a Water Code section 1055.3 requires the board to consider all relevant circumstances. And you are right, this may have marginal relevance, but I think it does have some relevance going back to Mr. Simoni's state of mind and his attempts to comply with the rules here. Now, obviously you may disagree as to the weight that should be given to that evidence, but I would like to give him a chance at least to testify to that. So here's what I'm going to do. I'm going to, let's just take a break. It's 10:50 now. Let's take a break till 11 o'clock. Please, whatever you do, don't log out of Zoom, but you can turn off your cameras if you want, and I will. And let's see if we can find that letter, the 1995 letter with the red markings from Division of Staff and Water Rights staff and get it up on the screen. So we'll be on break for 10 minutes. We'll come back and we'll see where we are then.
I ask a question, Mr. Lilly. I'm not sure what you're doing because I don't have real good command of all this electronic stuff. But my question is, are you going to try and go through the electronic transcript and find it? Because it's a letter sent to me. It's not something that the board would have. Now, I could take a picture of the letter and maybe get it to you in 5 or 10 or 15 minutes somehow. But
okay, well, was it sent to you from the Division of Water Rights?
Well, it appears to be sent to me from Edward C. Anton, Chief Division of Water Rights, because there was a little typed note that was attached that, like I said, has not been very helpful.
Okay, let's do this, Mr. Simoni. Let's do that as a backup. If you can take a picture of it, do you have a way to email that picture, or is there some other way you can transmit that picture?
I can possibly email. I've never done this before, so I'm just going to give it a shot. I would be able to take a picture of it with my phone and possibly email the picture, send the picture to you.
Okay, let's do this. This will take, we're going to give you 10 minutes, and you may either email it to admin hearing, it's ADMIN HRG office, that's our email address, at waterboards.ca.gov. Or if that doesn't work, you can text it to me on my office cell phone, and I will try to figure out how to get it to everybody. And my cell phone is 916-217-4944. 4216. It's been in the emails I've sent in this matter. So Mr. Simoni, 10 minutes to take a picture and either email it or send it to me by text message. In the meantime, Mr. Anderson and I are going to work on trying to see if we can get it from the water board files. We'll all come back then. And Mr. Lewis, if you have further objections at that point, I will give you an opportunity to state them. And then Mr. Simoni, I will give you an opportunity to continue your testimony. So as I say, take a break. Go. You can go on mute and go off video, but please do not log off, or you might have trouble getting back on.
Well, that would
And
be
I'm going
my,
to do the same.
Mr. Simoni, one quick
how
question.
do I go on mute?
Is there a water right ID associated with the letter?
Okay, I'm back and we're waiting for Mr. Simoni. I did receive your text. I've sent it to Mr. Anderson and he is working to get it posted on the screen, so please bear with us. And Mr. Lewis, please bear with us. We should be able to have those. There were two, just for the record, there were two different pages that Mr. Simoni sent us, and we are working to get those up on the screen. So just everybody hang on until we get those. We're trying. It's a little bit tricky because we have 3 different people all working remotely. Okay, so thank you, Mr. Anderson. That's the second photo. Is there any way you can get up the first photo to start with?
Well, you probably want to make this the first one because that's what you would see when you first read it.
Okay, that's fine. So, Mr. Anderson, please put that back up on the screen. We had it. He's getting it back.
I lost.
If we need to, we'll just take another short break, but he had it up there, so I have hope. He certainly has far more technological ability than I do. Okay, so now we have, just for the record, and just everybody be patient here. Mr. Anderson has put up the second of the 2 photos that Mr. Simoni texted to me, and I did not talk to him at all. I just received this text from him. We will mark this, and just for the record, as best I can see, this is a July, there's some previous page in his file which talks about statements of water diversion and use July 1977, but that's not what we're focusing on. What we're focusing on is a letter dated July 24, 1995. It's marked copy at the top right-hand corner. It's from Mr. Simoni to Mr. Leininger at the State Water Resources Control Board. And then it has some red markings on it, including an underline of riparian use and correct. And then there's a stapled page at the bottom, which says the attached material is sent in reply to your recent report. If it does not meet the purposes of your inquiry, please communicate further with, and it has the State Water Resource Control Board address and Edward Anton, Chief, Division of Water Rights, listed there. So we will mark this as Simoni Exhibit F. And after the hearing, we will put this into add this to the folder of Simoni exhibits.
Mr. Lilly?
So yeah, let me just finish. So I just want to make sure our record is clear for that. Obviously, Mr. Simoni will need to explain this, but I think Mr. Lewis, you want to say something first. So please go ahead.
Yes, I'd like to object to this exhibit. There's no identifying date or additional information on the attached receipt that would indicate that this receipt belongs to this letter.
Okay, well, Mr. Lewis, I think your objection may be premature. Mr. Simoni has not offered it into evidence yet. He still has to establish a foundation. However, he has explained this is a copy of a page in his file, so I suspect he will be able to provide some explanation. So let's do that, and then if he wants to offer Exhibit F into evidence, then you may object at that point. But I am going to allow him to testify regarding it, and if he can, to establish a foundation for it. So let's do that. Mr. Simoni, please go ahead and you may testify regarding Exhibit F. Remember, you are still under oath, and let's proceed that way.
In response to my July 24th letter, all I got back was this, my 24th letter back with some red markings and something that is trying to convey a message, which is not using English. It is simply reporting back that correct, which I assume, and I'm that it's supposed to try and say that, yeah, I'm supposed to report on riparian use. And then it gives us some attached forms or laws, but it attaches it. I was received this, and with the letter there was this stapled, this small little note, which tells me that here's something for you to read, is all I can get from it. It's not signed, it's not dated, so I have nothing else to say. But this is what I received back.
Okay, so and Mr. Simoni, you've got to help us here since we're all working by teleconference. Could you please just pull up that stapled page at the bottom? We won't be able to see it because we just have your photograph.
The the first picture shows it. The other picture shows the bottom.
Is the first page the same letter without that stapled page? Is that correct, Mr. Simoni?
The other photograph, yes, there it is there. If you pull up
so that's the same thing, but so we can read under the label, basically.
Right.
So we will mark this as a Simoni Exhibit G. And I do appreciate your sending us both, because otherwise I was always going to wonder what it said, the red words under that attached label. But for the record, Exhibit G is the same letter as Exhibit F, except we no longer have the stapled page at the bottom. And with that removed, we can see red markings which say "see attached /WR." So, okay. So with that, Mr. Simoni, is there anything else you would like to say about either Exhibit F or Exhibit G?
No, it's just but the point of this is be as illustrative of my testimony, that in fact, this is the only communication that is directed to me personally by the State Water Board in 20 years. And I made repeated attempts to call and to communicate both by writing and in other methods, so I could discuss the problem that I perceive with the reporting in the forms. Now, it is clear that by 2006, we still hadn't. Now, remember, I didn't own the water right at that time. By 2006, they were still coming to us, and in PT, I forget which of the exhibits that the water board put up, there was a supplemental statement, and I pointed out that it talked about 150 acre feet. And there was still confusion on our parts, because we see this about once a year. We assumed that even in 2006, that they were still sending us our annual appropriative water right reporting form. And in fact, in that exhibit, which is the 2006, 2007, and 2008 supplemental statement of water division and use, we make note, well, we used our 150 acre feet. And we try and mark out the months when we usually use it. And that we state that there's no meters and we're pumping from the creek as well, okay? So it was unclear to me what water right we're talking about. We checked both the riparian claim and the appropriative claim. We said other, we wrote in appropriative right. So we were thinking, well, the riparian claim is the same as this form wants to know all the water. Well, this is the best we can tell you with our system, okay? So we did everything we can, even as far as 2006, to comply. Now, how in the world, we don't have numbers for our water system. No one wrote us necessarily saying, okay, this water right has this number. Okay, we are getting these forms and we're trying to figure out what they mean in a very busy time period. So there was no intent not to file, but there was an intent to communicate with someone to talk about the riparian system. Because all this testimony about the damage to the water reporting and forecasting is not realistic, especially as to this section of the Uvis Creek. Because in this section of the Uvis Creek, it's a riparian water right. All the users from the Pajaro River, up from the below the Uvis Dam, all the way up to Svedal, are governed by a judicial determination of how the water is to be used. And in fact, as long as there's water in that creek, I could double the amount of cattle I have on my ranch and pump water to them without any restriction, because that is my property right. And in fact, it's self-enforcing, because if I don't pump, the water goes down the creek for someone else to use. There is no doubt it's a usufructory right. You have to use your water, and you have to use it for a beneficial purpose, not to sit there and put it on the chemise, okay, or to put it in a pond, because then you're appropriating water. So we have done everything we can to continue to report, but the water board doesn't want to talk to us. And I submit my November 19th, 2019 letter as evidence of that fact. That is me telling the water board, please talk to me. Please talk to me. Okay, I've called and called, but no one returns my calls all that year. So in desperation, I wrote a letter. And I still haven't gotten a discussion. Okay, now that is what the problem has been all this time. Now he says, well, I didn't report in 2018. Well, unfortunately, and I believe I wrote you out of desperation because I couldn't figure out who to write to. The forms have so much information. There's no way I can sit down in the amount of time we have available to digest it and to respond. And so what I've been doing is starting to add addresses and just write everybody so I can get it done. That's all we're trying to do here. So my problem is I sent the reports as I said, you're wrong. We filed our reports. Okay. And I sent those out, I believe, to somebody in the water department, but no one responds back. They just said, no, we're here. You give us money because this is your fault. Well, the form itself is not right. There are many questions that have to be answered about this form. Not only that, you're talking about a riparian right where I have the rights to the water. You're chilling the effect that I have of being able to use my water. Okay, so as far as that goes, I never received any notice of a workshop, nor do I think it was necessary. All I needed was 15 minutes to 30 minutes for someone to go through the questions and I could answer them. But no one wants to talk to us. It's easier for them to sit at their desk and produce demands because they have computers now. Okay, and it's easier for them to create a form that says, you did not, you have to comply in this certain way. It's easier for them, but that's not what the truth is. That's not what we're working with. We're working with something that is an actual real function in reporting and what you can use. There is no harm that Mr. Cervantes talks about to the reporting system. His testimony is wrong. It is based on an inaccurate view of what's going on out there in the real world, not just in, oh, my paperwork doesn't line up, okay? The real thing about reporting the water use on the Uvis Creek is that if you put a sensor or have a man go up there at the base of the Uvis Creek and sit something in the water every month, like the USGA used to do, and Santa Clara Valley Water District does, you would see whether the creek is flowing and you would find out how much water is coming down. And you would not interfere with the rights of the upper water users who have the right to use the full flow of the creek. okay, especially in this jurisdictionally regulated part. So we can use it for commercial use anytime we want. That's our legal right. Okay, so there's no harm to the reporting. It doesn't stop how they can manage and manage how much water is in the state and being used in the state, because we have the right to determine how much of our water is being put to beneficial use in a riparian section, not the appropriative section. I can only use 150 acre feet in the appropriative section. I understand that. But in the case at bar, at least in my situation, we've tried to comply every time we can. The real need for a monetary penalty is the other big issue here. Do they really need to send me edicts from their desks to make me comply? If someone is making a mistake and trying to figure out what is going on with this system, especially when in fact they shouldn't be reporting at all in a riparian system because of the way the system works and it is self-regulating, why am I getting all of these things? Well, all they need to do is communicate with me. They're not doing that, okay? You just make edicts. Oh, well, here, we'll do a workshop for a whole bunch of people. That is not what's constitutionally required when you're going to assess a penalty or when you're going to punish someone for failure to comply, especially when they're making every intent to comply and they're confused, which we have been for many years. There's not one letter been sent to me in response. Not one person has called, and Mr. Cervantes admits it, that no one has called us and said, what's going on here? Why is this form not reported properly? You know, what's going on with you guys? And we could talk about it and figure it out. It took us a long time to figure out how to go into this electronic system that you now want, this Orwellian system. And I have to describe it that way because it is so flawed constitutionally with requiring a certain type of demand without giving you the option of filing anyway so you can comply. So they prevent us complying. Then they want me to pay the money because I failed to do what they want. This is not constitutionally acceptable. It is not humanly acceptable. It violates every human principle.
Objection.
Go ahead, Mr. Lewis, please state your objection.
Relevance. The constitutionality of the statutes are not in question.
Yes, they are.
Well, Mr. Lewis, I think he's allowed to raise the argument. I'm not saying I agree with it, but isn't he allowed to raise an argument that a statute is not constitutional?
Your Honor, Mr. Lilly, the prosecution team's opinion is that the time to object to the constitutionality of the statute is during the rulemaking process and not during a hearing on whether he failed to comply with the statute.
Okay, I'd certainly note your objection. Mr. Simoni, I'm going to allow you to raise your argument, although frankly, I think you've already raised it quite well in your letter. I think we understand your point here. You've made it very clear, and I certainly understand it, about the lack of responsiveness from the Division of Water Rights, and you've made your legal arguments in your letter. So I'm going to allow you to continue, but I'm going to ask you to try to complete this within 10 minutes if you can.
I think I complete it in 5 because I'm right at the end.
Okay. 5 would be even better. Thank you. And yeah. I lost a little track of time because we ended up with a 15-minute break, but please go ahead and let's try to wrap this up in 5 minutes.
There hasn't been one reasonable attempt to talk to me and to help me clarify what they're doing and why they're doing it and to state my concerns. And that's why in desperation, I asked for a hearing because it seems to be the only thing Amy going to talk to me is here. And I know I'm not going to get the type of discussion that I need to have, but I am assembling the information I need to go to my legislatures because this system that has been created is in fact, it is oppressive and it is chilling our rights and interfering with our ability to do business in the water board. Now I'm going to answer Mr. Lewis's statement that the constitutionality is not in question. I think he's dead wrong. The
Okay,
Constitution,
that, Mr. Simoni, is probably best. I mean, it's obviously best addressed through legal argument. We're in testimony right now. So
Fine.
when you're done with testimony and cross-examination, we'll talk about whether to do closing arguments or closing briefs. But I mean, you're a lawyer, you understand the distinction.
Right.
So let's save the legal arguments for either closing arguments or closing briefs.
Yeah.
And I certainly will not cut you off from making them. It's just not during testimony.
I appreciate it, Mr. Lilly. So anyway, we've tried every time we can to comply. Anytime we've realized we've made a mistake, we've complied. And then Mr. Lewis earlier on, part of my testimony, said, no, I'm not going to talk to you. No, I'm not going to talk to you. I got these rules that I can oppress you with. Okay. And that's what I'm going to do. That was uncalled for. That's uncalled for. It's unbecoming of an attorney in my mind. Very much so. Especially when you run across facts like this and someone who's trying to comply, looking for someone to talk to. No one has talked to him for years, especially this last year. I did receive one phone call Monday from Elizabeth in the Water Rights Board. I have not returned the call. So that was the only other call I think I've ever received from the Water Rights Board two weeks ago. You know, I did use some help to try and understand how in the heck to get on this electronic filing system. It has taken hours for me to do this. It is oppressive. It is absolutely oppressive. And that's the only testimony I have now is there's never been a statutory reminder, and that's my my testimony. Okay.
All right, thank you. So I'm going to pause for just a minute for Mr. Lewis to complete his notes. And then when you are ready, Mr. Lewis, you may proceed with cross-examination.
Thank you, Mr. Lilly. Thank you, Mr. Simoni, for your testimony. I have a few questions. First, you mentioned that Uvas Creek is an adjudicated creek.
Correct.
Does a water master file your supplemental annual report pursuant to that adjudication?
Not to my knowledge. There's the water master retired. We have been doing it on a voluntary, managing the creek on a voluntary basis. In the drought, we voluntarily went on to the, me and the neighbors went on to the water pumping schedule voluntarily, and we've been able to manage it voluntarily since then. We've been through 2 droughts this way.
Thank you. Ms. Mullen, can you please present Mr. Simoni's Exhibit B? Thank you. Next page, please. Thank you. This page. Mr. Simoni, do you recognize this document?
Oh, I don't recognize it specifically. I'm sure it's my handwriting on the document.
Okay.
What
Mr.
page?
Simoni, this is Exhibit B, your 1995 Supplemental Statement of Water Diversion and Use.
Yes.
Can you please read that first line underneath the title where it says statement number?
Yes.
What does that say?
It says S something. S00486.
Thank you. And can you please go down to where it says in the next paragraph, source? Can you read that?
No.
Okay. Let me call.
I'll just state for the record, it looks like it says source Uvas Creek.
Thank you. I can read it.
Thank you, Mr. Lilly. And Mr. Simoni, where it says complete and return, underneath A, can you please read that line?
Water is used under.
Okay. And can we please note that under riparian claim, there is an X?
Yes.
Thank you. Ms. Mullen, can you please go down to the bottom of the document? Next page, please. And Mr. Simoni, at the conclusion of subpart F, can you please read what it says, beginning with "I declare"?
If part of the water listed in Part C consists of reclaimed or
Oh,
polluted
sorry, just where it starts with "I declare."
under penalty of perjury.
Okay. And whose signature and printed name is that?
That's my signature.
So it's safe to assume in 1995, you filed a riparian statement with statement S000486.
I filed a guess.
Thank you.
I had no idea what the number meant. Nor did I connect the number to the
Ms.
repair.
Mullen, can you please pull up prosecution team exhibit 2?
Excuse
Mr.
me,
Simoni.
what was that last exhibit we're reading? Because I may have to use that later.
I think we were on,
exhibit.
Mr. Simoni, we were on about the third page of your exhibit B before.
Oh, okay, thanks. Go ahead.
And now we're on, up on the screen is exhibit PT2.
Oh, there it is, 500, 700.
Mr. Simoni,
Yes,
it is your testimony that the State Water Resources Control Board never reached out to you. Is that correct?
that's correct.
Do you recognize this letter?
Yes,
What's this letter?
gobbledygook as far as I could see.
Thank you. This is the February 15th Division of Water Rights letter. Can you please read who it is addressed to, Mr. Simoni?
It's addressed to me.
And is this an address where you receive correspondence?
Yes, it is.
Thank you.
And I also
Ms.
note it
Mullen,
says,
can you
appropriate
please,
right.
can you please pull up prosecution team exhibit 5?
What was the last exhibit again?
We had PT2, now we're putting up PT5.
PT3, two.
No,
Okay,
it was PT2, now we're on to PT5.
that's fine.
And now PT5 is on the screen.
Yes,
Thank you. Mr. Simoni, do you recognize this letter?
well, I didn't recognize it when I got it. I'm assuming I knew that this is my name, my address, and it says a warning of deficiency. And I remember getting the letter and thinking to myself, what are they talking about?
And who
Filed.
did this letter come from?
Pardon me?
And who did this letter come from?
State Water Resources Control Board.
Thank you.
It wasn't in response to anything
Ms.
I
Mullen,
sent.
can you please go to the last page of prosecution team exhibit 5? Mr. Simoni, can you please read the water right ID?
We might want to make it, let's make it a little bigger to help him read it.
Yeah, I mean,
Help me read it too. Thank you. Some of us with old eyes need a little help. Thank you. Now we're on page 2 of exhibit PT5, enlarged so we can read it. Please go ahead. Maybe Mr. Lewis, just ask your question again now that we have it clear in front of us.
Mr. Simoni, can you please read the water right ID?
S000486. What does that?
Is this the same water right ID that was filed on your 1995 attested annual report?
Not to my recollection. I didn't know that there was any. I was confused as to which ID applied to what.
Mr. Lilly, please let the record reflect that the water ID in the August 30th notice of deficiency matches the water right ID in the 1995 supplemental statement of water diversion and use.
Yeah, well, we both exhibits are in the record, so we certainly can look at them as we need to.
Lastly, Ms. Mullen, can you please pull up prosecution team exhibit 8 redacted?
It's PT8, is that what you're looking for?
Yes. Mr. Lilly.
Okay, PT 8 we will get.
Thank you. And can you please go to page 2?
And
Oh, sorry. No.
hang on a second. Let's let her make it bigger.
Yeah. Sorry.
Maybe-
Can we go back to page 1? I didn't think it would. Okay.
Okay, yeah, just tell us what part of page 1, but she's made it bigger so we can read it, but tell us where you want her to scroll to.
Scroll down, please. Okay, right there. Mr. Simoni, it's your testimony that you've had extreme difficulty filing the supplemental statement of water diversion and use. Is that correct?
Correct.
Can you please see prosecution team exhibit 8, last line, where it says supplemental statement of water diversion and use for the 2009 reporting year? Can you please read the date of when it was filed?
I can't find that. Which date is that?
And I'm going to help out here because it's a little confusing because we can't get the whole page up on the screen, but I believe, and I don't think there's any dispute here, but Mr. Lewis, correct me if I'm wrong, but if I go 1, 2, 3, 4, is the 5th column where there's the entry 8/03/2018? Is that what you're saying? There's a heading at the top that says data filing?
Correct.
Yes.
Okay, so Mr. Simoni, and if we need, Ms. Mullen will scroll up, but I think the question is, do you see that? I'm sorry, Mr. Lewis, with that explanation of the exhibit, why don't you restate or say your question?
Mr. Simoni, can you please read the date you filed your 2009 supplemental statement of water diversion and use?
8/3/2018.
Thank you. And Ms. Mullen, can you please click the view link so that we can see the August 3rd, 2018 electronic filing?
I don't know if that's going to work because we're in PDF here.
Okay.
And that's not in the record. So if you want to, Mr. Lewis, we can get it and add it to the record, but we're going to have to do a little more mechanics to get it into the record.
Yes, please, because I would like to note that it was Mr. Simoni who attested to that electronic filing.
Okay, have you submitted that as an exhibit before?
No.
What are we talking?
And I don't think that is in the record. And again, I said you didn't have to submit exhibits ahead of time, so I'm going to treat you the same as Mr. Simoni. And that one I know we can get. Well, I'm pretty sure we can get, but I want to have it marked as an exhibit and up on the screen if you want to ask him questions about it. So if you want that, we're going to just have to take a break and we will get it and put it up on the screen and mark it as an additional PT exhibit.
Alan, can you hear me?
Yeah, just go ahead, Skylar. Please go ahead.
Does he want 2011?
I think he wants the statement for 2009. Is that correct, Mr. Lewis?
Yes, Mr. Lilly.
Okay, so Skylar, Mr. Anderson, how long will it take you to get that?
About 5 seconds.
Okay, I don't think he's going to do it that fast, but he's good. So we're going to get it. Oh, he is good. All right. So is this what you're looking for, Mr. Lewis?
Yes, Mr. Lilly.
Okay, so I'm going to just say for mechanics, and Mr. Anderson will make a note of this, and we will add it to the record. But we've put up supplemental statement of water diversion and use for 2009 for statement number S000486. We have page 1. I think it probably has 2 or 3 pages. And we will mark this as exhibit PT 12. Is that acceptable to you, Mr. Lewis? That would be your next exhibit number.
Yes.
Okay, so that will be marked as PT 12. It's the first page is up on the screen. We can get the other pages. Please proceed with your question.
Thank you. Ms. Mullen, can you please scroll to the bottom?
And this might be Mr. Anderson. I think he's got the screen now, but we'll get it. Okay, so keep going down. Is that where you want it?
Yes, very bottom of the screen, Mr. Simoni. Says contact information of the person submitting this form. Can you please provide us the name of that individual?
James Simoni, I think. Is that what you're trying to say?
Yes, thank you. That's everything, Mr. Lilly.
That completes your cross-examination? All right, thank you, Mr. Lewis. I do have just a couple of follow-up questions for you, Mr. Simoni.
Sure.
There's just a couple of background things I'd like some information on. Can you please describe the facility that you operate to divert water from Uvis Creek under the riparian rights that you've referred to today?
Well, it's hard to describe physically. We have two pumps. One is inoperable at this time. There was one on the south end of the ranch, which is inoperable. And there is one at the north end of the ranch. I think the report describes of a 12 to 15 horsepower pump that goes into the creek by a foot valve and pulls water directly from the creek when it's flowing. There might be a berm that is built each year, which I couldn't build this year. So we are not able to irrigate at this point in time until some equipment is repaired. The foot valve then goes into a irrigation line that runs the length of the south end of the ranch that we installed years ago. And the goal being that we could irrigate our fields and use the irrigation line to do it. Okay.
All right, so then that was my next question, actually sort of led into it. Do you use this water for irrigation then, is that correct?
Correct, both, everything. The water is used for irrigation, it is used for domestic, it is used for livestock maintenance. The part of the confusion here is that all of the facilities that you're talking about are a function of the Uvis Creek. So Hay Canyon, even Hay Canyon is a function of the riparian water rights of the Uvis Creek. And so in trying to complete these forms, there was no guidance as to, well, what are you talking about? So every year, whenever I filled out a form, I'm guessing. I haven't a clue because I can't get any communication.
Okay, I understand that. You're getting a little off track here. Let's try to stay on track. I'm just asking some basic questions.
Oh, how you describe the facility. Okay, so anyway.
Wait. So let me ask the question. So you've mentioned irrigation, domestic, and livestock. So what kinds of crops do you irrigate with this water?
It used to be permanent pasture or Sudan grass is what we've used in the past down in the flats, and that's where our pipeline goes to. So though it's mostly crops that are used for the maintenance and raising of cattle. The other is, of course, livestock maintenance. So
okay, yeah, I'm going to get. Let me just stick with irrigation. Right, you have to let me go one step at a time.
Sure.
I'll get to the livestock next. But for irrigation, then, how many acres do you irrigate with this water, approximately?
We have approximately 100 acres that are irrigable.
And so you use the water to irrigate approximately 100 acres.
Yes, and that's stated in the lawsuit that we talked about. Each user has specified in the report of the water master that was filed in that lawsuit how many acres each person is entitled to, because by that we determine what portion of the creek water that party was entitled to. Now we are
again, I just want basics here. How many livestock do you water or provide water to from this water source?
We presently will be providing water to approximately 50 to 60 mother cows, calf. Yeah.
And then you mentioned you use the water also for domestic. Is that true?
Correct.
So do you have some kind of treatment so that before you use it for domestic?
No.
Okay.
No.
And how many people receive the water from Uvis Creek for domestic use?
Well, it varies over the years, and that has changed. But I would say approximately there are three residences on the property. So there can be as many as there could be as many as 12. Right now, we're down to 2.
So between 2 and 12 people.
Vacant. Yeah, 12 to 2, typically.
Okay, so again, I'm trying to get a picture. We can't go out on site here, which would be the easiest way to see it, but your explanations are very helpful. So you irrigate approximately 100 acres, provide water to 50 to 60 mother cows, and then
Right.
domestic water for, we'll just say, between 2 and 12 people, depending on circumstances.
Any time, yeah.
Okay,
And that could change.
so those are the only things you use this water for, is that correct?
Pardon me?
Are those the only things you use this water for?
Well, no, the maintenance of the livestock.
Yeah, no, I mentioned that, the 50 to 60 mother cows. Okay, so
Right.
those three types of use.
Those are the three types of use presently. Now, I can't say that won't change because our neighbors use it for totally different uses.
No,
which
I
we-
understand. I'm just mainly talking about what you do now and what you've done in recent years.
Yeah.
So, and then I think you mentioned in your testimony that you've mentioned the lawsuit between you and your neighbor, which resulted in a judgment and a water master. Is that correct?
Correct.
And I think you said that the water master is now retired. Is that correct?
Correct.
So did the water master ever file reports of water use with the Santa Clara County Superior Court?
Our understanding was that it was regarded as unnecessary.
Okay, so as far as you know, what the water master, even when he was working, did not file reports.
Correct. He would
Do you know
monitor.
what years the water master was working to implement this judgment?
Shoot, I can't remember now, but I know it was in the 60s.
Oh, in the 60s. Okay. I didn't realize the judgment was that old.
Oh, yes. This
Okay, so
was in high school.
okay. And so but then when did the water master retire?
In the 60s, I think. He acted about 10 years.
Well, wait. My time, the 60s were 70 years ago. So, or no,
Well,
I'm sorry, 60 years ago. When was the last time the water master did any work implementing this judgment?
I can't give you the exact year, but I know it might have been after 1974 because my dad died in 1974. I'm trying to remember if he was alive at that time or not. I believe he may have retired sometime shortly after that because I remember looking for another water master, a volunteer water master during that time period. After the 70s or late 70s, I looked for a volunteer water master.
Okay, I take it you never found one. Never found one.
No, well, we started acting voluntarily, so it didn't have a problem. Once the schedule was published, it just took a few calls to the neighbors, and especially in the droughts in 78 and 1914, no, not 1914, 2004 2014 was the last serious drought, and all it took was calls to the neighbors, and everybody went on the schedule.
Well, that's good. We always like it when people can work things out, which sometimes it happens and sometimes doesn't. So, all right. Well, thank you, Mr. Simoni. I don't have any other questions. So, Mr. Lewis, do you have any follow-up? I'll make sure I do this in the right order. Yeah, let's just start. Do you have any follow-up questions following up on my questions?
No, Mr. Lilly.
Okay. And then I mean, it's a little tricky, Mr. Simoni, with you having to testify and effectively ask questions as well. But we don't need to go on if you don't have anything else. But I do want to give you an opportunity if you think there's any explanations you need, and you don't need to repeat what you've already covered. And frankly, I think you've covered it all very clearly. But do you have any follow-up testimony you want to give following up on either Mr. Lewis's cross-examination or my questions?
No, I don't think I do.
Okay, I think we probably are getting pretty well through here. All right, so Mr. Simoni, we have your exhibits now that you submitted with your letter on Wednesday, and I think it was dated Tuesday, July 21, and we received it on July 22. That had exhibits A through E. We today have added exhibits F and G. Do you want to offer those exhibits into evidence at this time?
I would offer A through E as truth of the matter asserted. In exhibits and evidence, I would offer the last two we put in the record as illustrative of my testimony.
Okay.
I've been contacted by the Bureau of Water Board.
All right. And Mr. Lewis, do you have any objections to any of these exhibits A through G?
Our objections for the last two exhibits still stands.
Okay, maybe you better state what those are, because I think before I was concerned that you were saying lack of foundation, and Mr. Simoni has now explained what they are. So maybe you should restate your objection now in the light of his testimony explaining what they are.
The objection is still foundational in that we're not able to verify that the attached piece of paper was from the original.
Okay, I'm going to overrule that objection, Mr. Lewis, for F and G. I think that goes to the weight of the exhibits, not the admissibility. Mr. Simoni's testimony certainly provide sufficient authentication for them to be admitted into evidence, but we will consider your objection in terms of the weight to be given to the exhibits. So with that, exhibits A through G of Simoni are admitted into evidence. Now, let's talk about where we go from here. We can do this one of two ways. This is closing statements or closing arguments. And I'm amenable to either one. I'll ask both of you how you want to proceed. We can either have short closing arguments now. And again, this is not to repeat testimony, but to make legal arguments. You're both lawyers, you understand the distinction. Or if you would prefer, I can give you a short amount of time, and this would be in the order of 1 to 2 weeks, to submit written closing briefs. And I don't require them to be in any particular format. They can either be letters or you can do them on pleading paper. I do think they should be limited to either 5 pages, which is plenty, more than enough for a single space letter, or 10 pages for a written brief on pleading paper. So I'll start with, maybe I'll start with you, Mr. Simoni. Which would you prefer, oral closing argument today or a written closing brief?
I would prefer oral because we do not have the resources and time to devote to doing any more research on this matter. I think that we've made the case. I think that the law is fairly clear on the point.
Oh, okay, that's fine. I'm just, you'll get to make your argument just a minute. So Mr. Lewis is, Mr. Simoni has said he prefers oral closing argument. That's the way we normally do this for these annual report cases. Is that acceptable to you as well?
I need to ask a procedural question first, which is whether you're going to consider Mr. Simoni's motion to dismiss. Because
okay.
And
the answer is I will consider that as I prepare the proposed order, but I'm not going to rule on any motions today. And I'm not going to rule on any motions before they prepare the proposed order. So that anything like that will be addressed in the proposed order. That will be the only substantive ruling for me in this matter.
If you were going to consider the motion to dismiss, then the prosecution team requests that we do written briefs.
Okay, and let me just make sure I understand. Do we have a written motion to dismiss, or is that just the oral motion to dismiss today? I think we just have the oral motion to dismiss. Is that correct?
Correct.
Mr.
That's my
Lewis?
understanding.
Okay, and Mr. Lewis, that's your understanding as well?
Yes.
Okay, I think, Mr. Simoni, that Mr. Lewis does have a right to submit a written response to that. So here's what I'm going to do. I'm going to allow closing arguments today. As I say, I think we've covered this all very well. You both had very detailed opening statements. So I'm going to say 10 minutes per person for oral closing arguments. And then I'm going to allow briefing of I will refer to as the motion to dismiss issues raised by Mr. Simoni. Those briefs are optional, but either of you may or may not file it depending on what you want to do. And I'm going to propose, today's July 24. I'm going to, let's say 2 weeks. So that would be August 7. If my calendar is right, August 7 will be the deadline for written closing briefs. And I'm going to say those are limited to 5 pages, single space letter, which is way more than you need. So don't feel like you need to do that. Or 10 pages of double spaced on pleading paper. You can do it either way. And with that, and again, obviously, when you file them with me, with the hearings office, I prefer you file them electronically, but if you can't, you can file them by paper. You just make sure to mail them to the address that's listed in our hearing notice. And of course, serve them on the other parties. And Mr. Lewis, because of the email problems with Mr. Simoni, I ask that you serve him both by email and in paper, as you've done with the last matter.
And Mr. Allen,
Last set of exhibits. All right, go ahead, Mr. Lewis.
Mr. Lilly, can you please outline the scope of the motion to dismiss
Okay.
issues?
All right, let's do this. Mr. Simoni, the answer is no, I cannot do that without going back to look at the recording. But Mr. Simoni, can you, as succinctly as possible, state what you believe are the arguments for the motion to dismiss, if this is separate from your closing argument, so that Mr. Lewis will know what to respond to?
The reporting scheme is unconstitutional on its face because it does not statutorily require the notice. A courtesy notice is simply an officious statement to the diverter that we're your ruler and we'll just tell you when we want to tell you if you have to report. I think there has to be an actual notice, like the paper notice we used to receive, that the form itself is violative of the Constitution as due process because it requires you to give answers, and it fails to let you report if you cannot give the answer the way they want the answer. They create the form, and then it punishes you for it. The form has a chilling effect on a water right that is far more expansive than a quantitative water right because it's a riparian right. It's a riparian right that is governed by the amount of water flowing in the stream, not quantitatively, but actually. And so you can adjust your use based on if there is sufficient water, you can pump. So those are the constitutional requirements based on the motion to dismiss.
Okay, so Mr. Lewis, I hope that summarizes the arguments Mr. Simoni has made sufficiently for you to be able to prepare your responsive brief. Do you have any questions about that?
I have a procedural matter. This is a motion, so when Mr. Lewis submits his brief, if he insists on doing a written brief, I would ask that I have the time for a reply brief. So I think what he should do is he should submit his written brief if he so desires, and then after that time, I'd be given some time to reply to his written brief in writing.
All right, so Mr. Lewis, is August 7th sufficient for you to prepare your written response to this?
As I understand procedurally, isn't it the respondent who provides the first brief and the prosecution team is given a chance to reply?
Well, and that's a good point. Mr. Simoni, you've stated your arguments, but obviously have not provided any legal support for them. So I am going to do this. Mr. Simoni, if you want to make this motion, and again, you've raised the issues in your opening statement and presumably can raise them in your closing argument. So we can address those issues as part of the ruling on the hearing. But if you want to do a separate motion, I am going to agree with what Mr. Lewis just said, that you need to have a written motion with citations to legal authorities so he has something to respond to. So I'm going to give you a choice. Either you make the motion in writing with citations to legal authorities, or if you don't want to do that, we'll just limit it to you can make the arguments in your closing arguments today. So which way would you like to proceed?
Well, Your Honor, again, we're back to the question of whether I'm going to orally argue this case or whether we're going to put it on in a written form. The prosecutor requested to put it on, and he was replies in a written form. I presented my motion as part of the oral record in the case. My feeling is if I elect to do it in an oral form, then there should be no writings by either parties, and they should make their arguments orally today. And my motion to dismiss, being it is as like a motion in limine, does not have to be in writing. And so
okay, so this
Right.
is what I'm going to do. We're not going to do any written briefing then. We are just going to have closing arguments today. You may make your arguments as you deem appropriate, and then the matter will be deemed submitted. So I've changed my mind after the back and forth. I certainly, I don't want the situation where one side is submitting legal arguments in writing and the other side doesn't have an opportunity to. And if we go down that path, we would have to talk about who goes first and who goes second. But I don't think that's going to be necessary here. So unless either of you has any objections, I'm going to be a little more lenient because there may be more to say. But I propose that we wrap this up with closing arguments, which if you want to characterize it as a motion, you can, although I'll tell you, I'm going to just treat them as closing arguments because there's no real process for me to rule separately on those. So I'm going to propose 15 minutes for closing argument by Mr. Lewis and 15 minutes for closing argument by Mr. Simoni, and it's submitted. Does either of you have any objections to going that way? I'll start with you, Mr. Lewis.
Yes. If I need to respond to Mr. Simoni's motion to dismiss and closing arguments, I want 5 minutes. I would like 5 minutes to prepare.
All right, that's fine. That is the normal way we do it for trial process. So let's do it that way. 15 and okay, we'll just say 15, 15, and 5. I don't think you're going to need that much. So, all right, Mr. Lewis, you may proceed with your closing argument. Then Mr. Simoni, you'll do your closing argument, and then Mr. Lewis, you'll have an opportunity for rebuttal. That is appropriate. Are you ready to proceed now, or do you want to take a break before we proceed?
I would like to take a break, Mr. Lilly.
All right. Is 5 minutes sufficient, or do you want more?
Can we please do 10?
All right, 10. All right, so it's now rapidly approaching noon. We'll come back at 12:10, and then we'll proceed with oral closing arguments along the time frame I just talked about. And certainly you do not need to take the whole amount of time, but I'm going to allow 15, 15, and 5, and then the matter will be deemed submitted. So again, please do not log off, but you can go on mute and you can turn off your video, but we'll all be back at 12:10. Thank you.
I don't know how you turn off the video.
Honey, where are you? Okay, see if you can delay this. They're gonna make me do a final argument here, and I won't be able to get out of here till 12:30, 1:45. So see if she will allow you to see if you can delay it an hour or two. Because the rest of my day is free. Yeah, okay, I'll talk to you after the hearing. Bye-bye.
Okay, it's 12:10. If everyone can please unmute and turn back on their videos, we'll go ahead and get started again.
I'm there. Okay.
All right. And others do not, since Mr. Prager, hello. So the witnesses and others do not need to unmute. So Mr. Lewis, you may proceed with your closing argument. And it's 12:10. So as I said, I said 15 minutes, although frankly, you probably don't need that much, but a maximum of 15 minutes. Please proceed.
Thank you, Mr. Lilly. This is a very simple case. This matter is regarding whether Mr. Simoni failed to timely file a supplemental statement of water diversion and use report for the water year 2018 before the July 1st deadline. Respondent claims that the State Water Board does not communicate with him. This is incorrect. On multiple occasions, the State Water Board sent letters to Mr. Simoni in attempts to help him comply with the requisite requirement. These letters inform Mr. Simoni of the need to file his riparian statement with the specific number. They provided instructions. They further informed the diverter that he would be able to call the State Water Resources Control Board or email the State Water Resources Control Board in order to receive help filling out this form. The State Water Board reviewed call logs. The only time Mr. Simoni contacted the State Water Resources Control Board's numbers was June 15th, well after his failure to file this report by the July deadline. Ultimately, Mr. Simoni did file the report 344 days late. Mr. Simoni also claims that his appropriative and his riparian rights are mixed up, that this inability to distinguish the two prevented him from being able to comply with the statutes. However, the evidence shows that as early as 1995, Mr. Simoni knew that statement S00486 was a riparian right. He attested to it himself and filed a report with the State Water Resources Control Board. Mr. Simoni claims he was also unable to navigate the electronic systems in ERIM's report management system, and that this also prevented him from being able to file the requisite report by the deadline. However, evidence again shows that as early as 2018, Mr. Simoni had the requisite knowledge in order to be able to submit the supplemental statement of water use and diversion report, and again, attested to his filing himself. It's for these reasons that the State Water Resources Control Board recommends a penalty of $2,000 for Mr. Simoni's failure to timely file the 2018 supplemental statement of water diversion and use. Thank you.
All right, thank you, Mr. Lewis. So Mr. Simoni, it's like I've got 12:13. Mr. Lewis did not take anywhere near the whole 15 minutes. I'll give you 15, but you don't need to take it if you don't want to. So please proceed with your closing argument.
First of all, the statutory scheme is unwieldy and uncomplicated for an ordinary person. And I'm a lawyer and I had trouble with it. It is invalid constitutionally on its face because it doesn't require the board to give notice of the filing necessity, which the paper filing did in the first time. The electronic form dictates how it's supposed to be filled out. And as a result, it doesn't allow you to file and puts you in a situation where you cannot file. Oftentimes, that is why the first statement was well into 2018, because of the fact that we were trying to figure out the system. This punishes the people that are trying to comply. The statement is also should ask only one question. What are you doing with the water? Constitutionally, we're entitled to any amount that the creek has, regardless of the amount, as long as it is beneficially used. The form has a chilling effect on our affecting and using the water right, because they're constantly trying to overlook us and we have to be able to restrict our right or not restrict our right based on whether or not some Orwellian governmental body is judging what we are doing. The whole system is constitutionally defective. Now, as to the compliance that they are talking about, we have tried to comply. We have tried to comply many times. We have been guessing to comply. We have a supplemental statement. The interpretation of the evidence by the opposing counsel is at best false. Okay? That is not the evidence. The evidence is clear that I saw a supplemental statement of water division and use and didn't know what it was for. Numbers don't tell me anything. Okay? Especially when they keep coming at different times. What in fact happened was I saw a thing that said supplemental notice of diversion and use. Well, that must mean that it's in addition to the appropriative notice I'm already getting. That's supplemental. It's supposed to be something more. So in one time I fill it out and I put riparian. I may have forgotten to check the appropriative box, but then we try and describe how we're using it because we don't have meters. So we kept telling them, we don't have meters, we don't have meters. So we comply as we have done with the Santa Clara Valley Water District, which is telling them in a different context or a different ranch at the time that, or some of my different users, the use we made by describing the amount of water that were normally used by this operation as it existed at the time. We attempted to comply, and it's pretty clear that the statement that, oh, this is simple, he knew everything he was doing and he voluntarily gave us the finger and didn't want to comply. Nothing could be farther from the truth. The fact that we thought this is just extra is nothing that we were able to get dissuaded, because the lie of all this is I contacted the water board far more times than June. Many times I tried contacting them and communicating with them, and no one over 20 years responded except with one letter, which was red ink and trying to sit there and say, oh, well, here's what it's about. And in fact, it labeled supplemental. In another one of the forms, it says appropriative water right users. Okay, this isn't simple. It could be simple. A simple question, how did you use the water? That's all it needs to say. As to other users, it's certainly not specific. Okay, the evidence is that I tried mightily to try and comply with the regulation and give them their report. Now, there is for sure a mistake one time that I misunderstood what they were asking for, and we just sent them all of our reports and said, we filed, what are you talking about? Okay, and no one replied. No reply. Okay, now admittedly we have to change the reporting, because from what they're telling me is one report, a riparian report, even though all of this is part of one system in the Uvas Creek, they're saying the riparian report now is going to be separate from your appropriative report. Okay, that this form is only, even though it's supplemental, it's supposed to mean there's supposed to be another report that starts it. It's supplemental, so that means it's supposed to be for one right, which is a supplemental right, of course. What, are we nuts? What is going on here? There's been total confusion on our part. And we can't sit there and be legal scholars looking at every administrative regulation. I'm not paid like Mr. Lewis here, who sits there and he can read all this stuff and he gets paid to do it. We don't make any money doing that. Our argument here is that we tried everything we possibly could to try and comply with this thing. And when we finally realized, oh, here's what they're asking for. Okay, I still don't think it's the right report. I still don't think that it tells me what I need to give them, but I'm going to guess and I'm going to give them something because I got to file this. I certainly objected at the beginning when in fact the report was saying that it had to be under declaration of penalty of perjury. These reports have qualitative statements denying, and they are I've forgotten the word now. They're redacted reports that that their language in them that say, look, this is the wrong thing. Please help us. No one reaches out to talk to us about it. In fact, the evidence will show by Mr. Cervantes that they don't read the reports. They don't read the reports. They'd have realized that they had a confused diverter if they'd read the report, because their interpretation is that it's a riparian report. I'm reporting on the appropriate of water right in one of the reports. I'm guessing because I have to comply because they're going to do exactly what they're doing now. That if I fail to file something, they're going to try and hold our feet to the fire because they are the rulers now. They are the rulers. Okay. This is not the way an administration is supposed to administer water rights. This is totally Orwellian. It is wrong from the bottom to the top. Now, as to the evidence itself, again, the evidence shows that we tried to comply. There's never been an intent to fail to comply. Okay. And they have made it so confusing and so unwieldy to try and reply that now they get to have their way with us. It's unfair and it's wrong. Okay, it's wrong. So that is my feeling. There is no evidence that supports a need to have an economic sanction against any diverter under this system when they're confused like this. If they would just have called, just answer one of my phone calls. What do you need, Mr. Simoni? 15 minutes of our time? That's all. Here, I have some questions. What do you mean by the 1914 right? When it starts under this form, when did your water use start? Well, the water use may have started back in the 1850s. Okay, what do you mean by that? Do you mean when did I acquire the right? When did my parent acquire the right? Or do you mean when did they first put a pump in the creek? I don't know what you're talking about. Okay? This form is a chilling effect on anybody that tries to ranch or do anything he wants. So there is no evidence in the record. It's certainly not beyond a reasonable doubt or beyond a preponderance of the evidence that I failed to file and refused to fail to file and was not respectful. There's no evidence in the record of that. But in fact, there's evidence that the board doesn't use these reports for the very purpose they're given. But the worst part of it is that the reports are a useless vehicle in any case because the riparian system regulates itself by the natural flow of the water, at least in this portion, in the Uvis Creek. There's not enough water. I mean, if this was the Snake River, maybe there's something to be said. You better tell us how much you're using, okay? But in the Uvis Creek, I guarantee you, if you don't pump, the water's gone. It leaves, okay? And then if you do pump, you're only going to get what's there in summertime, and you're not going to get any more. So there's no need for regulation here, and there's no way they can control that. Mother Nature controls that on the Uvis Creek. They're not trying to look at the specifics of the tributary and the water system that they, quote, think they're regulating. They don't regulate it. It's the riparian system, and it's constitutionally protected. And in fact, if you look at the Constitution, the code section, it specifically says, nothing herein contained shall be construed as depriving any riparian owner of the reasonable use of water of the stream to which the owner's land is riparian under reasonable methods of diversion and use. That's the limitation they say that's put on riparian water rights. I submit to you that that's not a limitation even relevant to this creek. Nature controls this creek quite completely. So I think those are my closing comments. There is not sufficient evidence for any economic sanction. This system needs to be overhauled. And in this case, in the Uvis Creek, there shouldn't be reporting required. It's not necessary for any kind of statement of planning or use of water in the state of California. That's all I have to say.
All right, thank you, Mr. Simoni. Let me just get another page here in my notes. So Mr. Lewis, you may proceed with your rebuttal.
Thank you. Mr. Lilly, the prosecution team has 2 points on rebuttal. First, Mr. Simoni's constitutionality arguments are nonsensical. The California Constitution, Article 10, Section 2, lays out the policy for the state's water resources. It requires that water be put to beneficial use and that use be reasonable. In addition, that policy allows the legislature to enact laws as necessary in order to implement that policy. This legislature did enact such laws when it required the filing of a statement for an initial diversion and use report. The State Water Board is also granted with the authority under the Constitution to be able to make such reasonable rules and regulations as it may from time to time deem advisable in carrying out its powers and duties under this code. The State Water Board attempts to implement the beneficial use and reasonable use policy through reporting regulations. As Mr. Cervantes testified, this provides the board with critical information that allows it to implement regulatory programs that are necessary to ensure that water is put to beneficial use. Prosecution team's second point. Mr. Simoni appears to have a history of failing to respond to the letters and information received by the State Water Board. Instead, turning and pointing the finger at the State Water Board, stating that we've failed to communicate with Mr. Simoni, when in actuality, we've made all reasonable attempts necessary in order to provide him with the instructions and information in order to comply with his requisite statutory obligation. The division is not required to provide this additional supplemental support to aid these diverters. However, the information is so critical to the State Water Resources Control Board that a program has been created and measures have been put in place to give all diverters every reasonable opportunity to timely file their reports. Mr. Simoni has disregarded these letters and has not followed the instructions and advice and opportunity for further assistance that they provided, and failed to file his report until 344 days after the July 1st deadline, depriving the board of information that it so desires in order to implement the constitutional policies of beneficial use and reasonable use. Thank you.
All right, well, thank you both. First of all, I want to thank you all for bearing with us. It's not easy to do teleconference hearings, but I think we're all getting pretty good at it. Not just for water board hearings, but as part of life over the past several months. And I think we were able to get all the information presented and work through the exhibits. And I appreciate both of your patiences for working with us on that. I certainly want to also thank Nicole Mullen and Skylar Anderson from my office for their technical assistance, which was timely, very professional and well done, and basically allowed the hearing to keep going. So with that, as I mentioned at the beginning of the hearing today, I'm deeming the matter submitted as of today. We will prepare a proposed order within 90 days as required by law to submit to the State Water Board, which then may consider it as its legal provisions allow. And I certainly will make sure that we transmit that proposed order to both of you at the same time we transmit it to the board. And we also, of course, will post it on our web page. So thank you all for your cooperation today. I hope you all have nice weekends. And as I say, we will be in touch when we have the proposed order. So thank you and goodbye.
Thank you, Mr. Lilly.
Thank you, Mr. Lilly. Thank you, gentlemen and colleagues.
All right, goodbye.